welcome back Mel Myler from Faculty Being Education. Also, we have some subs today. Sitting in for Moffat is Alan Bernstein. For Nelson, he's not here. Aiden Ankenberg. Connie Lane for Representative Porter. Brian Sullivan for Representative Mullen. And Mary Beth Walsh and she's not here yet. Anyway, okay. So we're going to start here on executive session. Public hearing, I'm sorry, I'm ahead of myself. Public hearing on a non-germane amendment 2022-0734H to Senate Bill 236. And I recognize Glenn Cordelli for testimony.
Thank you, Mr. Chairman. Thank you, colleagues. For the record, Glenn Cordelli, representing Tufton Borough, Moulton Borough, and Sandwich in the beautiful Lakes region. This is a non-germane amendment to Senate Bill 236. The purpose for this amendment relates to confusion basically over the term secondary school. There has developed a situation in at least one middle school in which teachers are teaching same grade pre-algebra and algebra classes that are taught in the high school. They both have student loans, and under the student loan forgiveness program, one teacher is receiving their full $17,000 in forgiveness, but the other teacher is not, because they are teaching the 8th grade algebra classes. So as you'll see in the letter, I think that it should have made its way around from Division Chief at the U.S. Department of Education. It explains the situation and the confusion over what is a secondary school. In several places, as pointed out in there, secondary school is defined as a junior high school program. In several places, it is defined as anything above elementary school. And actually in rules, they are two different categories. There's elementary and then secondary, and that's all that is covered in rules. So secondary is clearly not elementary, so would be junior high school as well as high school level. So in the non-germane amendment, as you can see in lines 18 through 20, it defines teachers in grades 7 through 12 to be considered secondary school teachers, which will satisfy the student loan office and allow both teachers teaching the same course to receive their full loan forgiveness rather than just the half, as is currently been decided by the loan office. So that's the basis of the amendment. Representative Hill, who has brought this forward, will be here to testify. He's in another committee at the moment, as is Representative Hobson, who is the prime sponsor. So I'm about fifth down in the line in relation to this amendment, but it's my pleasure to present it to you.
Anybody have any questions? Representative Woodcock.
Thank you, Chairman. Morning, Glenn.
Good morning.
As regards the license on a licensure or certification by the state for faculty in those grade levels below the typical high school level, below the 9 or 12, those in the middle school. Is that going to have a repercussion or a domino effect on licensure certification? The requirements being different for those two grade levels?
I don't believe so, because as specified in lines 18 and 19, it's for the purposes of this program that it's defining the grade 7 through 12 teacher as secondary. And in rules now, it's basically just elementary or secondary education.
So there won't be any certification changes on the state level?
Right.
Okay.
Correct.
Thank you. Thank you, Mr. Chairman.
Thank you. Representative Janice.
Thank you.
Only been here for how many years? Anyway, sorry.
Thank you. And thank you for taking my question. I actually have two questions. One is I noticed in the current law, in different places it references a separate organization consisting of grades 7 through 9 or a separate organization 4 through 8. By calling it a separate organization, does that mean that it's not a school district? Or can it be tuition schools?
Is there a particular statute you're referring to that where that distinction is made?
In your amendment, 189.
Oh, okay, I'm sorry.
On line 13, and then it's repeated again on line 15.
Right, that's in current statute now.
That's
existing.
Yes, it's existing language, but
Right.
I'm wondering if that means that that covers schools for tuition purposes and Prenda and those kinds of.
I believe this is talking about public schools in this section of law.
Okay, and my second question is, how can we, at the state level, influence federal teacher loan forgiveness programs?
I think as indicated in the accompanying letter, I think that if we clarify that, as we did in lines 18 to 20, that those grades are considered secondary for the purposes of this program, I think that from everything I've been told, should satisfy it so that the teacher can get their full loan forgiveness payment.
Any other questions? Yes, Representative Bruno.
Sure. Thank you very much, Mr. Chair. Is there going to be any retroactive, I guess, loan forgiveness for maybe a teacher who taught in 7th or 8th grade prior to the establishment of this policy?
I don't believe so, but I'm not in the loan forgiveness business, but I would not expect so. But
So thank you very much. Thanks for taking my question. Do you think then it's fair to move forward with this while other teachers may have been excluded from loan forgiveness?
yes.
Thank you. I get one point. I remember some years ago, on the committee, we passed a bill allowing students to take courses and then they get credit for those courses in high school if they were taken at a lower grade. And I remember in our high school, with the algebra, for example, in the 8th grade, and Spanish, and taken in the 8th grade was the same course as taking in the 9th grade, the same books and everything. And so, remember when I was on the school board, because it was law, we passed it so that those students can get the credit for what they took in the 8th grade. And I know Londonderry even starts sooner. In the 7th grade, they can take algebra. In the 8th grade, they can take geometry. So, I mean, depending on the student, they have to meet the qualification. So, yeah, I think this is probably a good bill and probably being done already. So, but for the loan forgiveness, yeah, I think it's fair. Just my comment. And, Representative Myler.
Thank you, Mr. Chair, and thank you for taking my question. It's more of a statement, I think, than a question.
And it's a follow-up to Representative Luno's statement. I think the loan forgiveness is a good program. The dilemma is that you've got other teachers that are also teaching kids. And you've got elementary teachers who, for example, are providing a baseline for learning math, for example, and yet they get no credit for that. So this is not a criticism of the amendment here, but it's a criticism of the policy that you take a section of teachers and you say, okay, you can have a special deal here, but the others can't. And I think I object to the theory that you take a particular group of teachers and provide them with preferential treatment rather than dealing with teachers in general that provide the foundation for math, etc. So that's really more of a criticism for the concept of segmenting out certain people to get certain things and not recognizing the value of others by giving them the same benefit. So it's just a statement. Thank you.
Thank you. And I expect if Representative Hill makes it here, he's been very involved in this issue. He, I'm sure, would be glad to explore further your comment.
Representative Woodcock.
Thank you, Chair. I don't know if that's for you as the chair or Representative Cordelli. Can you explain to me what NHHEAF, the supplemental piece, what that organization is? Supplemental piece that came with the amendment?
I am not sure what the acronym stands for. Perhaps Representative Hill is aware of that. I was trying to figure that out myself, but yeah, I'm not sure.
Okay. Representative Luno, do you have the answer to that?
Specify what that is.
So, thank you very much, Mr. Chair. I believe it stands for New Hampshire Higher Education Assistance Foundation, and it, I think, traditionally involves itself in FAFSA completion, student FAFSA completion for sophomores and juniors in high school, and it also advises students and families on their ability to obtain loans and scholarships for higher education.
Okay. Thank you so much for your clarification. Thank you, Mr. Chair.
Senator Hall? I mean, Representative Hall.
That's okay.
I was
I'm
in
a
the
senator
Senate
for today.
hearing earlier.
Thank you, Mr. Chair. Yeah. And thank you for taking my question. I'm just wondering about certification versus what you teach. So if you were an 8th grade algebra teacher and you were certified in elementary ed, but you're teaching, you've been hired to teach the algebra class, are you still qualified or not? It looks like it's not based on certification, but rather if you have a bachelor's degree and you are teaching the science. Is that right, or do we know that?
I am not sure of that, but you know, it seems that there are subjects that are offered both in high school and in the upper middle school, if you will, or within any secondary that basically are the similar programs.
So if I'm not certified in mathematics, but I am a certified teacher, I have a bachelor's degree in elementary ed, and I've been hired to teach that, I would get the loan forgiveness, do you think?
I am not that familiar with the provisions of the loan forgiveness program.
Okay, thank you.
Any more questions? Okay, thank you, and I guess we'll recess for a few minutes and see if we can find Greg Hill. I know Senator Khan is in the Education Committee downstairs in the Senate. I was just there, so Call Representative Hill to speak on 232.
Thank you, Mr. Chairman. Thank you. I hope I didn't hold anyone up.
Yeah, you did, but. Go
Well,
ahead.
I apologize to everyone. I'm here to speak on an amendment to 236, mostly to explain a situation that happened in my school district. As most of us are aware, oftentimes when you hear a story from a constituent that just sounds so crazy, you find out generally it is crazy and there's an important piece missing. In this case, it wasn't. It is crazy as far as I can see. The situation was in Winnisquam School District, we had 3 math teachers in grade 8. They applied for loans for education, continuing education. 2 of them applied with one lender, 1 of them applied with a different lender. When it came to the teacher forgiveness program, the 2 that applied with one lender, that lender looked at our statutes and deemed the reimbursement to be based on a high school level or secondary level. They paid or reimbursed $17,500. The one teacher that chose a different carrier, their legal team looked at our statutes and had an opposite view and said that they were a primary or an elementary school teacher, and they were reimbursed $5,000. So all this amendment does is say, for purposes of the teacher loan forgiveness program, K through 6 will be considered elementary school. 7 through 12 will be considered secondary school. And that's all it does. It allows, we have letter upon letter here from the superintendent who's saying it really doesn't matter. They're all teaching in 8th grade, this high school level math, so they should be here. They went as far as to the U.S. Department of Education, and because our statutes in different areas refer to those grades in an ambiguous way or in different sections one way or another, rather than try to change those different sections, it just made sense for them to have something to point to as, see, for purposes of this is the legislative intent. So with that, I'll be happy to answer any questions, but I hope you consider
Any
it.
questions? Representative Luno.
Thank you very much, Mr. Chair. Thank you very much, Representative Hill, for taking my question. You'd mentioned that the particular teachers in question were teaching high school level math in 8th grade. In that school, are you aware of any 8th grade math teachers who are not teaching high school level math and would otherwise maybe not feel that they were entitled to the $17,500 in federal loan forgiveness?
Thank you for your question, Representative. I am not aware, 2 things. I'm not aware that they were exclusively teaching what we would call high school math. I'm only going by the description that was sent to the Department of Education and from the testimony that I've given you from the teacher herself. I'm not sure it was exclusively one way or the other. I think they do incorporate, I think they say here, pre-algebra as well as Algebra 1 classes. So for me, I consider Algebra 1 high school, and pre-algebra I consider 8th grade, but I may be wrong.
Follow up on that?
Yes.
Thank you very much. And as a follow-up then, is there a distinction to be made among, let's say, 7th and 8th grade teachers who may not be teaching high school level math courses or science courses? And I'm not trying to talk about exclusively teaching high school math and science, but ones who don't teach any high school level math and science. Like, for instance, some schools might have a class called 7th grade math. And maybe I'm a math teacher at one of those schools, and I teach 7th grade math. I teach, let me just say three blocks of 7th grade math every day. And I don't teach anything else. Would that teacher feel that they met the requirements of this section, or the section as amended, for to be considered to be a high school teacher? I'm just trying to figure out what motivated these teachers to want to make this distinction, and whether or not it's being applied, and I guess how it's being applied in this.
Thank you for your question. If I understand it correctly, I want to make sure that the committee is aware this is not just dealing with science and math teachers. This is, the amendment speaks only to 7th through 12th being considered secondary, regardless of the subject matter that you're teaching, 7th through 12th, and K through 6 being considered elementary. That's all it does. And the reason I think it's simpler to do it that way is because that's what this program that reimburses deals with. It doesn't deal with the subject matter in any way, shape, or form. So there's no distinction that I've seen in any of these teacher forgiveness programs that we have here from any of the lending institutions. They're not talking about what's taught, or what percentage, or by whom. That's how I understand your question.
That's fine.
Thank you.
Any other questions? Representative Tanner?
Thank you, and thank you for taking my question. So there's no, so this is basically a federal program that we don't have at the state level, but we have state financial institutions that deal with student loans, who are making different decisions, and we're trying to make it equal. Would that be a good summary of what?
I think
We're
you
doing-
should have been the one testifying,
Okay.
Representative. Thank you very much. That says it perfectly.
Okay, any other questions? Seeing none, I'm gonna close the hearing on SB 236.
Thank you.
And we're gonna open the hearing on the non-germane amendment 2022-1431H to Senate Bill 352, and I recognize Representative Glenn Cordelli.
Thank you, Mr. Chairman. Thank you again, colleagues. Glenn Cordelli, representing Tufton Borough, Moulton Borough, and Sandwich in the beautiful Lakes region. And I am introducing a non-germane amendment to Senate Bill 352. This amendment has come about based on a contact I had with a counselor a couple of months ago. And it relates to a federal grant program that is being piloted in a number of districts in New Hampshire. And this program relates to student behavioral and wellness issues. And as part of the requirements of the program, counselors are required to enter into a third-party database personally identifiable information about students, including name, address, SACID, and other behavioral issues. I believe if a counselor sees a student more than once, they are supposed to enter information into this database for tracking of possible behavioral issues. The counselor feels that this is in violation of her ethical standards as a member of the counselor profession. And as pointed out in the American School Counselors Association materials, school counselors recognize primary obligation regarding confidentiality is to the student, but balance that obligation with an understanding of the family and their legal and inherent rights to be the guiding voice of their children's lives. And there are more things in the ASCA literature about confidentiality. This situation escalated within the past month, and that the teacher was threatened with being written up for insubordination if they did not enter this student private information into the database. I reached out to the Department of Education, and their legal staff looked into it and looked into all the forms and agreements with this third party that this one district has in particular, and found it to be in line with federal law. And that law is FERPA, the Family Educational Rights and Privacy Act. In 2008, FERPA was expanded to allow districts to share personally identifiable information from student records without parental notice or consent with any third party designated as a school official, including contractors, consultant, volunteers, and other parties to whom the educational agency has outsourced institutional services or functions. It was again expanded in 2011 to allow, again, disclosure without parental notification or consent with organizations for the purpose of conducting studies. So I think probably I won't go against the Department of Education lawyers, but I think that they're probably correct in that it does not violate FERPA. But the counselor still feels that it's a violation of her ethical standards. And so she has since recently resigned her position in the school, which tears her up because she loved her job. The Department of Education is working with a third party that services multiple districts to see if they can scale back the amount of personally identifiable information that is being provided to that third party. So, not realizing that I can do much about federal law, I've submitted the attached amendment that would at least provide for parental notification when student confidential information is being released to a third party, and that the department is aware of this and does not see any legal difficulty with this, in that the information is still being provided to the third party in line with FERPA, but we are just notifying the parents that this has occurred. And I think, we've talked about parental engagement and so forth quite often this year in this committee. So I think that this is the least we can do in this situation. And I would ask for your support for the amendment.
Thank you. Any questions? Representative Tanner?
Thank you. I kind of feel like I'm working behind a curtain because I don't know who are the third party people, and what kind of surveys and all the things that this might actually impede. I'm wondering if the Youth Risk Behavioral Survey, for example, is one of the ones where student information is given to a third party, or I would just like more detail before I make this decision on this wide-ranging bill or amendment. Thank you.
Um, yeah, I think surveys are covered under a different section of federal statute, and we're not talking about surveys. They're actually entering this information into a third-party database. In the case of this one district, it is a behavioral institute associated with Keene University, Keene College.
Representative Ludo.
Thank you very much, Mr. Chair. Thank you very much, Representative Cordelli, for taking my question. Would the FERPA exceptions to parental consent include state and local authorities within the juvenile justice system?
I thought I'd have to look back, but there are a number of exceptions that I didn't mention in my testimony. But I have part of this is excuse me wrong.
Okay,
section.
follow up, Mr. Chair.
I can get you the FERPA.
No, I'm actually looking
exceptions.
at it. It's a rhetorical question.
Oh, okay.
It includes state and local authorities within the juvenile justice system. And so my follow-up question to that is, what sort of implications do you think disclosure to a parent could have in a case where state and local authorities within a juvenile justice system are being involved? And have you exhaustively explored what that impact could be on the families and the student? And I'd like to hear your comments on that. Thank you.
I think that parents have a right to know, generally, their kids. So if the school is providing information on their students to a third party, whether it's someone in the juvenile justice system or elsewhere, I think parents have a right to know. We've had legislation in the past about law enforcement being called on students, and whether parents should have the right to know that that is going on. And I come down on the side that parents always have the right to know.
So thank you. And could you comment a little bit on where maybe abuse and neglect is involved?
If that's being reported to the police, are you saying, or if something like that?
To authorities.
To authorities.
Correct. And
I think that if there is, let me backtrack. This is information that's being entered into a third-party database. Nothing is being happening with that information at the third party by the third party. My understanding is if the third party is presenting information, a referral to another agency, that parental consent is obtained in that case. So if the third party in this case is presenting that information, let's say to a psychologist or something, that the parent would be notified as part of this grant process.
Mr. Chair, just to be really specific on this, this is about disclosure by the school to a third party. So it's not a third party database. Okay. And this is about exceptions from the consent requirement. And what I'm hearing you suggest is that under no circumstances should there be any exception whatsoever to the consent requirement that a student's personally identifiable data. So it's not necessarily talking about their grades. It's not necessarily talking about their full record, but it's talking about anything that qualifies as personally identifiable data within a student's record, maintained by the LEA, disclosed to a third party pursuant to the exceptions that are detailed under federal law, of which one of them is state and local authorities within a juvenile justice system. And there are others too, that you don't see any, what you're saying, you don't see any situation where any exception should be made, that any parent should receive disclosure, that such non-consent disclosure has been made. Is that your testimony?
If the school district is providing identifiable information to a juvenile facility, juvenile justice law enforcement, let's say, I think that the parents have a right to know that. I think that if the information is being disclosed, I think in any event, the school should be talking with the parents about what is going on at home, if that's the area of your concern. But I think that parents need to be involved.
Representative Walls.
Thank you, Mr. Chairman. So I've been sitting here doing a little legal research, putting on my legal hat, and it turns out that federal law trumps state law when it comes to FERPA, that under the Supremacy Clause, federal law always trumps state law. Having said that, most of the cases have to do with disclosure, not with notification like you're proposing. But I think it raises, this is lawyer talk, I'm probably going to drive you all nuts, but I think it raises a valid question as to whether what you're doing violates the Supremacy Clause. And I think it may be putting us in a precarious position if we choose to go forward with this amendment, given there's multiple state cases that I'm finding here as I sit here and look this up from all over the country, with over and over again state courts and federal courts finding that under the Supremacy Clause, FERPA trumps state law in all these issues. So my question is, are you concerned about that?
I believe that that this law, the proposed amendment, deals with just parental notification. It does not block the release of that information under FERPA at all. So I do not see a problem. But there again, I'm not a lawyer.
Follow up.
So in the case that Representative Luna was talking about, that if you've got a case of abuse going on, say, for example, say you've got a father abusing his daughter and they want the school records from the counselor and they're going to notify the father of this, it seems to me that that could be a problem interfering in the case. And certainly we've seen those kinds of things happen. All my years on child and family law, I certainly heard about those kinds of things happening. So I think one of the perhaps unintended consequences here may be that we're interfering with normal processes to protect children. And I'm wondering if you have given that much thought and the implications of that.
In your question, if law enforcement was contacted, I would think that law enforcement would be doing an investigation, and a part of that investigation would be contacting the parents also.
I think the timing is an issue at this point. You know, I think law enforcement does things on their own schedule where they may want the records before they contact the parent in that case. So I think, you know, I think my concern is that this has unintended consequences of things that haven't been thought through, because this is based on one anecdotal situation. And I'm wondering if you've had other situations or thought about other unintended consequences of trying to do legislation based on one anecdotal situation.
Excuse me. I think it is more than one anecdotal situation, and that this is occurring in a number of school districts. The same process is occurring in a number of school districts in the state and around the country. So I believe it's more than one anecdotal situation.
Representative Myla?
Thank you, Mr. Chairman, and thank you for taking my question. Your statement that regardless, parents should be notified. And I would have a question, I guess, if I was a counselor dealing with confidential information, whether it be about abuse, whether it be about sexual orientation, etc., where you have a direct relationship with the student that may be contrary to what the parents believe in or what they want. And yet this would basically say, regardless of what that confidential conversation you might have with a child, that information, if it's transferred to a third party, must be given to a parent. Do you have any concern about that as it relates to the impact that it might have on the child? Should the information relate to issues that they may not be aware of, that the child is fearful of from the parents?
I think there are also many instances we've seen where perhaps information is being kept by the school from parents that should be communicated to the parents.
That's where you and I would disagree then.
Any more questions? Representative Woodcock?
Thank you, Mr. Chairman. Representative Cordelli, thank you for hopefully answering my question.
Hopefully.
Yeah, I'm looking at this more of the process. In line 25, you're talking the detailed records shall be included. What does that mean?
There should be information put in the student's educational record about the disclosure of this information.
But you said, but the word detail record seems to me to be pretty exacting versus I met with Attorney Walsh, discussed something, or she received information. That wouldn't be a detailed record. But we talked, and she reviewed the records of student Steve. All right. What details are going to be put in that record?
That is not specified, so I think that it has to be more than just the date of the disclosure, but there has to be more information provided in the student record in line with the information that right above that in 1 was provided to the parents.
Okay, so that doesn't really explain what detailed is, but okay. So, may I follow up, Mr. Chair?
Follow up?
Thank you, sir. Going back to line 22 then, or 23, it says the parents shall be informed to whom it released and the person. What does that mean, the parents shall be informed?
Parents shall be contacted. It could be a phone call. It could be in writing.
So if using the same scenario before, Attorney Walt came in to check on student Steve because of something that was relevant as a third party. So a call from the school saying from the council that the attorney that came in, that's it? That's informed, or it has to be, and it doesn't, just my question, I don't know what informed means, and then the informed doesn't line up with detailed. I mean, inform is, as you said, could be a call, could be a talk, could be email. So, but then you have detail. Those two words in the data, that conversation concern me, Reverend Cordelli.
Yeah, I don't see any problem between 1 and 2 there. It outlines 3 things that the parents are to be informed of. I would say that would be at least provided for in 2
Okay.
in
So
terms of
really
records.
It doesn't. Thank you. It doesn't really tell you what they're being informed, how to be informed, to what extent be informed. And finally, my last question, on line 24, what happens if the information was not for educational purposes? If the information wasn't, does it have to be released? If Attorney Waltz is investigating Stevie for, as perhaps the other counselor have referred to, for abuse or something else, does that information have to be, if it's not educational, does it have to be released?
If there is an educational purpose, that would be specified.
But if there
If
wasn't,
there was a behavioral issue, in this case with these grants, they could be behavioral issues that would be required to be entered into the third-party database.
but this says in the educational purpose for which the information will be used. My question is, if there is not an educational purpose, does this information have to be
Yes,
disclosed to the parent?
yes.
So all information,
If there is a
About everything.
third-party release, that information has to be provided, yes.
even if it's not educational?
Yes.
Thank you, Mr. Chairman.
Representative Tanner.
Thank you, and thank you for taking my questions.
Sure.
Representative Cordelli, can you imagine any situation where it would be in the best interest of the child not to release information to the parent?
I think that if you are providing information to a third party, it should be the duty of the school to also provide it to the parent. Parents can't be left out of the equation.
Follow up.
So you see, or you imagine that there is no circumstance that it is in the best interest of the child not to release information to the parent.
There could be a whole slew of hypothetical situations that, I don't know if I can think of at this point, but, there could be various hypothetical situations.
One more follow-up. Couldn't that be an unintended consequence, though, that if we're really concerned about the best interest of the child, and we know that in certain circumstances, certain parents, and again, I assume these are parents rather than guardians, so somebody may be a guardian of a child, and a good reason why they're a guardian of the child and not specifically the parent, and yet the parent is being advised of what is happening. Can you see that there's a possibility problem there? Since we're working on anecdotal cases here, I think hypothetical and anecdotal kind of mirror each other in some instances.
Well, I think here it's not anecdotal. These situations are occurring on a daily basis in a number of our schools. So I don't consider it anecdotal.
Not to be argumentative, although it seems like it's getting to that point. My question again is that this is parent, and we have guardians, we have grandparents who are having kids because the parents are incapacitated, perhaps maybe to drug abuse. And with this particular amendment, you're saying that that parent has to be notified if there's, and particularly in mental health issues, I believe, if a child has been talking to a counselor and a mental health person, third party needs some information, or the police needs some information. By having just the parents in this amendment, you've really set up a situation that could be, I think,
If you would
not in
like,
the best interest of the child.
if you would like to amend this and include guardians, I would have no problem with that.
Last question, Representative LaRue.
Thank you, Mr. Chair. I don't know if this is going to be the last question or not, but how would this read in terms of a school that contracts with a third-party cloud-based student information system where grades are updated on a daily basis with that third-party system? And would that be considered a currently an exempt disclosure under FERPA? including school officials with legitimate educational interests or organizations conducting studies or work on behalf of the school. And I guess the follow-up to that would be, what would you envision if parental notification and then filing notice into the file in such a case had to be done every time data in the student information system was updated, what that would cost in terms of local and state resources? And do we even get into sort of like a chasing your tail situation where if you're now updating the system to show that a notification that the system was updated, that you would then have to notify the system again in a situation that really is chasing the tail? But I'd be very interested in your position with respect to third-party student information systems, and frankly, your position with respect to the New Hampshire DOE in sharing personally identifiable information, including students' and families' addresses, with the department, and whether that would fall under this. Thank you.
I believe we have other statutes that come into play, and I don't remember the RSA number. For instance, with the company that's doing the statewide assessment, there was other statutes that come into play with that. I don't think that would fall underneath that, under this FERPA provisions. I'm not sure what, pardon?
The question is, how could it not? Student officials with legitimate educational interest. I mean, how could it not fall under the statute?
But there are provisions with the statewide assessment for what information, what personally identifiable information is provided. There's not a lot of personally identifiable information provided to that third-party company. And what is allowed is in statute in terms of just law that we passed last year.
Jesus. Oh. Okay, one more. This is it.
What about the student that's 18? They're 18 years of old. They're in charge of their records basically, but they're still in a public school or in a school situation. Do the parents get notified if anything happens on that in this particular?
If there's a guardian situation or if the student is 18, I would not object to an amendment to add those provisions.
Wait for a minute.
I would
Okay.
support those.
Okay, with that, I'm gonna, Representative Cordella, thank you. Is there anyone out there that would like to speak on this? I know there's no more pink cards, but we see the School Board Association, okay. With that, I'm gonna close the hearing on this bill amendment. And since we're still downstairs in hearings in the Senate, so we'll do a little recess until, I don't know when, to start the exec session. Because the Senate is also having hearings right now on our bills. I don't know. We can't tell the Senate what to do. We tried to work it out with them, but it just didn't work.
What we're gonna do is that we had
Yours.
planned on having a caucus prior to, but we couldn't do that because of the Senate ed going on downstairs starting at 9 o'clock. So we're gonna break right now for a short caucus. Hopefully it's short. They're still on the second bill down in Senate ed.
Oh, still on mine?
Yeah, still on that bill. And there's some folks down there waiting to speak on bills to come up. There's not as many people in line for those bills though, so those should go hopefully faster. But I don't know what transpired during the hearings this morning here, but if there is need for a caucus, this would be the time to do it. Before we get together, I would say it's based on what Senator Ward's doing down there, and they're just dragging. So I would say at least a half hour. unless somebody wanted to tie it into lunch as well. Now, I'm open to, you know, Mel, what are you thinking?
We've had our caucus.
You have,
No,
okay.
we're gonna need to talk again.
You might be able to talk about, there's 5 remaining bills as well. And Dave and I talked this morning on, there might be a few areas which we can do some discussion. But here we are at 11:10 now, by that time zone. Figuring it's gonna be, I would say, there's still a second bill, there's another bill, and then the Legislative Oversight Committee, a bill. So it's, I would say that's gonna be a half hour at least, then we're cruising in on lunch. You want to just break and have lunch and then come back at 12:30? Or is that
Are they gonna have more bills this afternoon,
the, who?
Senate?
They're gonna get, they're trying to get through them right now, this morning. I know it, I've got bills tomorrow to testify on as well. Mary Beth? Okay, what we'll do then, I need to have a caucus, because we have not discussed anything, so let's have that caucus right now and come back in about 20 minutes. Okay?
Got a second?
Yeah. Going some, oh, you know, for the caucus? Yeah, I think Patty had it right.
There's a FERPA has a list of disclosure.
executive sessions, please. You ready, Dave? Okay. Okay, the first bill which we're going to address, we'll just work our way down through the menu here. SB 233 relative to water bottling filling stations in schools. I'm going to hand the gavel over.
Thank you. Mr. Chairman, would you like to make a motion?
Yes, I'd like to make a motion of ought to pass on this, on SB 233.
Is there a second?
I'll
Is
second
it-
that.
Representative Luno, thank you. Any discussion by the chair?
Yes, I'd like to have some discussion. I believe we have an amendment for that on line 6 on the second page, if that's my,
Go.
if I'm correct. So I'd like to have Representative Luno present the amendment, please.
Thank you very much, Mr. Chair. I'd like to offer amendment 2022-1638H. It simply amends the effective date in section 2 of the bill from 60 days to 90 days. And I think it reflects testimony that we heard from the department in terms of their ability to enact rules in a timely manner. Otherwise, I think the bill is in good shape to move forward, and I thank the chair for making the motion of ought to pass.
And are you making a motion ought to pass on the amendment?
I am, thank
And
you.
I'm seconding it. Okay, so we have a motion on the table right now to move SB 233 as amended with amendment 16. No, we got to do the amendment first. Excuse me.
Right.
Trying to get the lunch, folks. So we'll have ought to pass on amendment 1638H. The amendment was proposed by Representative Luno and second by Representative Ladd. Is there further discussion?
We could do a show of hands.
Madam Clerk, yeah, why don't you just ask for a show of hands? All right.
Okay, may I see a show of hands, please, for Amendment 1638?
Good, it looks unanimous
Unanimous.
to me. Okay, so now we have the bill on the floor as amended, SB 233 as amended with 1638H. Is there further discussion? Madam Clerk, are you ready?
Okay, now I'm ready. This is a roll call.
This is a roll call.
Okay, this is Senate Bill 233 with Amendment 1638 ought to pass as amended relative to water bottle filling stations in schools. Representative Ladd,
No, go the other way around. I'm last.
I did. Representative Cordelli,
Yes.
Representative Litchfield is yes. Representative Bohm, Representative Lakis,
Yes.
Representative Burstein,
Yes.
Representative Hobson,
Yes.
Representative Ford,
Yes.
Representative Sodi,
Yes.
Representative Ankerberg,
Yes.
Representative Myler, Representative Luno,
Yes.
Representative Cornell,
Yes.
Representative Tanner,
Yes.
Representative Waltz,
Yes.
Representative Sullivan,
Yes.
Representative Woodcock, Representative Lane,
Yes.
Representative Hall,
Yes.
and Chairman Ladd.
Yes.
So this passes 19-0.
Any objections to putting on consent? No objections, thank you. Next bill which we have on the docket here is SB 236, establishing a committee to study New Hampshire teacher shortages and recruitment incentives and non-germane loan forgiveness. Well, that's not right now, so we have the, yeah, I guess, and non-germane, that's part of the title, isn't it? Okay, so we have a motion, Representative Hobson.
Yes, I'd like to make a motion to auto pass as amended.
As amended.
It's not amended.
Representative Lakis, do you have a motion?
I second.
Thank you. So we have a motion on the table to pass the amendment, the non-germane loan forgiveness amendment to SB 236. Discussion from the maker?
On the amendment, correct?
Yes.
Okay, so this amendment for the purposes of teacher student loan forgiveness programs, 7th and 8th grade shall be considered secondary schools. There has been a big difference in the reimbursement rate between primary and secondary schools, and this change to the RSA will provide much needed loan forgiveness for teachers.
Thank you. Representative Lakis, do you want to speak to that?
I just wanted to add that when I got my secondary ed teacher certification for math, it was 7 through 12.
Okay, further, one thing we usually do, we usually put the amendments forward after we have the bill, you know, a motion on the bill itself. I don't think we've ever had a motion on this bill, have we?
Did Representative, your initial motion, was that,
On the amendment or on the bill itself?
was, ought to pass with amendment?
Well, in all honesty, I was not here when I was assigned the duty, so I was wondering if
None of us were.
potentially someone could speak to, make a motion on the bill, and I could make a motion on the amendment.
So what we need is we need a motion on the bill. And then after we get a second on that, then we can bring forward the non-germane amendment. We need to do it in the proper order. So any kind of motions that we had previously made, let's start over and who was the maker of the original? You, you want to take back that motion?
I will rescind my ought to pass as amended.
Okay, and who was,
I rescind my second.
haste makes waste, right? Okay, let's start this over again, please. Thank you. My mistake when we started that. I should have stopped it. SB 236, establishing a committee to study New Hampshire teacher shortages and recruitment incentives. Do we have a motion on the bill?
I'll motion ought to pass.
Okay. And there was a second from down there somewhere. Representative Myler, thank you and welcome very much. Representative Myler, having a chance to do it formally. It's good having you back on the committee. Okay, so we have a motion on the table. It's been made to move 236 ought to pass, made by Representative Hobson, second by Representative Myler. Representative Hobson, do you have anything to speak, care to speak to your motion?
I don't have anything to add, thank you.
Representative Myler?
Is there a motion on the amendment?
No, we haven't. We're just on the main bill.
Oh, yeah, this is an important piece because, as an example, as I was driving back over the holidays, I come by, I think it was New Haven, and there's this big billboard out there for encouraging people to become a teacher with the financial incentive. So this is happening all over the country. It's happening in this state, and I think this will give us an opportunity to really look to see what this shortage is and what are some alternatives to include people who may want to become teachers in the future.
And I would like to tack on to what Representative Myler just said. While I was downstairs at the Senate this morning, there was a lot of discussion in the hallway with the chair of the State Board of Education. And the department also recognizes the shortage we have in both elementary and secondary teachers and specialists in this state. And there's a lot of competition out there, as you all know, with those that come out with the content areas and especially the STEM areas and specialty areas from industry, which is able to really, double payment or triple the pay that you would get as a teacher. And people wisely are saying that's where my future is and I need those dollars, and they're opting to go elsewhere. We're also seeing, as a result of the pandemic, what we had in the last 2 years, there's burnout. There's also, it's not the same. And folks are dealing with, they're exhausted. And you also have issues coming in with sickness. And so with that, people are opting either to retire early or to to leave for another, what they may think is a greener pasture. And we are short to begin with specialists in areas, special education, especially with physical therapy and speech pathology and orthopedic and blindness and deaf, etc. And those people are also going to work at the hospital level, where they're getting a number of opportunities there, and again, a difference in pay. So the incentives and the need to be looking at teacher shortage issue is very real. And the department right now is also looking at this whole topic right now with groups over there, looking at the area of certification, alternative routes, looking licensure, etc. So the need for this is real. So that's my 2 cents worth. Representative Hobson, do you have a further motion to make?
I do. I'd like to offer an amendment, amendment number 2022-0734H.
Is there a second?
I second.
Okay, so we have a motion made by Representative Hobson and second by Representative Lekis to OTPA, the amendment was, I don't have it.
0734.
0734H. Further discussion from the maker of the motion.
Sure. I will repeat what I mentioned earlier. For purposes of teacher student loan forgiveness programs, 7th and 8th grade shall be considered secondary schools. There was a big difference in reimbursement rates between primary and secondary schools within the area of one lender, and this amendment changes the RSA to reflect that change.
Further discussion.
Yeah, when I got my certification, they did tell me that secondary, and this was in the state of New Hampshire, they told me that secondary meant 7 through 12. So 7 through 12.
Further discussion from members on the committee? Not seeing any. So Madam Clerk, can we have we're talking about the amendment now to the bill. We're voting on that amendment, which is, what is the number? 0734H. Yeah. We can do a left or a right hand if you want to. All those in favor, please put your hands up. All those opposed? That's unanimous. Okay, well, now we have a motion on the floor to amend SB, or for OTPA for SB 236. The amendment is 0734H. Any further discussion? Okay, Madam Clerk, would you please call the roll?
Representative Cordelli,
Yes.
Representative Litchfield is yes. Representative Bohm, Representative Lakis,
Yes.
Representative Burstein,
Yes.
Representative Hobson,
Yes.
Representative Ford,
Yes.
Representative Sodi,
Yes.
Representative Akerberg,
Yes.
Representative Myler,
Yes.
Representative Luno,
Yeah, yes.
Representative Cornell,
Yes.
Representative Tanner,
Yes.
Representative Waltz,
Yes.
Representative Sullivan,
Yes.
Representative Woodcock,
Yes.
Representative Lane,
Yes.
Representative Hall,
Yes.
and Chairman Ladd.
Yes.
Okay, the motion carries 19-0.
Any problems with consent? Not seeing it. Thank you very much. SB 350, relative to rulemaking by the State Board of Education on educational personnel applicant checks and licensing standards. I'd like to hand the gavel over to Vice Chair.
Thank you. Thank you, Mr. Chairman. And I would call on the chair for a motion.
I'd like to make a motion ought to pass on SB 350.
Second?
Representative Luno.
Yes, I'll second that.
Thank you.
Great. Thank you. Any comments by the chair?
I have no comments.
Representative Luno?
Yes, thank you very much. Let's see, this, I think we had a very good hearing on this bill and had some good discussions about why this will help to document exactly what the department is currently doing. And one of the things that was also presented was a draft of an amendment that was written by Senator Khan. We've prepared it in House form. I think it's gone around. I think we've actually got two duplicate versions of it, one by Chair Ladd and one by myself. Doesn't matter me which one, Mr. Chair, you would like to.
If they're duplicates, why don't you present it?
Then I'm happy to offer amendment, excuse me, amendment 1636H, which simply adds a provision to implementation of a secure system for accessing findings of abuse for individuals on the central registry pursuant to our state laws and other states' central registries upon approval of an MOU by the governor and council. And I believe we had talked, so that's what the amendment does. And I believe we had talked about that beginning with perhaps the state of Massachusetts, Mr. Chair.
And I'll second it.
Any further discussion from the maker or the seconder? Seeing none. Can we have any further discussion on the amendment? Seeing none. Madam Clerk, maybe we can do a hand vote.
Please raise your hands if you're in favor of Amendment 1636H.
Looks to be unanimous. So would you like to make an OTPA motion?
Yes, I'd like to offer OTPA on SB 350. The amendment would be 1636H.
Representative Luno, second.
I'll second that.
Further discussion? Seeing none. Madam Clerk, if you could take the roll when ready.
Yes, this is Senate Bill 350 with Amendment 1636H. Representative Cordelli.
Yes.
Representative Litchfield is yes. Representative Bohm.
Yes.
Representative Lakis.
Yes.
Representative Burstein.
Yes.
Representative Hobson.
Yes.
Representative Ford.
Yes.
Representative Sodi.
Yes.
Representative Akerberg.
Yes.
Representative Myler.
Yes.
Representative Luno.
Yes.
Representative Cornell.
Yes.
Representative Tanner.
Yes.
Representative Waltz.
Yes.
Representative Sullivan.
Yes.
Representative Woodcock.
Yes.
Representative Lane.
Yes.
Representative Hall.
Yes.
And Chairman Ladd.
Yes.
So the ought to pass as amended carries 19-0.
Good with consent? Thank you. Okay, where we are right now is we're looking at SB 352. I was not here for the presentation of that non-germane amendment. And I do have some questions which, and if there's going to be any amending of that, I need to speak with the speaker or to see if that, where we're going with that. And so with that, and we have one other bill today, 386. I got to track down the speaker to find out if an amendment to a non-germane amendment, how we, make sure that's done properly, if that's allowable, and what's going to be changed, whether it's title or not, and then I don't think it is allowable. But I need to get some discussion here, some clarification. So I'd like to take a half-hour break here, and maybe we have our lunch, come back and wipe this thing out very quickly, and we can be out of here by, I would hope, by 1 o'clock or 1:30 at the latest.
Perhaps, may I ask?
Yeah.
Okay. Perhaps before you take the trouble of going to the speaker, you might want to find out if there's enough support in the room for the amendment to begin with, because if the amendment's going to fail, you don't need to talk to the speaker.
Yeah, but I got to find out what the amendment's going to say too. So what I'm going to do is I'm going to just take, maybe come back at, 1 o'clock and then get it done.
Mr. Chair, are you talking about an amendment on 386 as well?
I don't see anything on 386 that I have. Do you?
No.
Are
So
there any amendments on 386? Representative Luno?
Not that I'm aware of. So can we exec that now? Oh, this is this is a technical change
That's,
that
this
we
is
were
the
all in the
DOE,
meet.
ADMA,
We
and
were in the meeting
ADMR.
on that.
This is no problem with it. 386 is gonna fly either way.
So why don't,
So we could jump and do 386
Let's
and
do
we can
that.
go out, get the clarification on that. I'll come back and take care of it.
great.
Okay, let's jump to 386 relative to the determination of state adequate education grants and charter public school tuition amounts.
I'd like to move on to pass.
Was that Representative Lekis? Did you make that motion? I was looking. Okay, thank you. We have a motion ought to pass on 386.
I'll second
And
that.
second, made by Representative Lekis and second by Representative Luno. Is there any discussion from the maker of the motion?
Just that this was all a result of an audit that had been done and it's just fixing problems found and it's mostly stuff that's already done. So that's it.
Representative Luno?
Yes, it was the testimony from the department that this documents current procedure.
Yes, they met with us and we need to go in this direction for our finances. So with that, any further discussion? Madam Clerk, would you please call the roll?
This is Senate Bill 386. The motion on the table is ought to pass. Representative Cordelli.
Yes.
Representative Litchfield is yes. Representative Bohm. Representative Lakis.
Yes.
Representative Burstein.
Yes.
Representative Hobson.
Yes.
Representative Ford.
Yes.
Representative Sodi.
Yes.
Representative Inkenberg.
Yes.
Representative Myler.
Yes.
Representative Luno.
Yes.
Representative Cornell.
Yes.
Representative Tanner.
Yes.
Representative Waltz.
Yes.
Representative Sullivan.
Yes.
Representative Woodcock.
Yes.
Representative Lane.
Yes.
Representative Hall.
Yes.
Chairman Ladd.
Yes.
So the ought to pass carries 19-0.
Any problems with consent? Thank you very much. So we will take a break now and we'll come back at 1 o'clock and put the other,
Just put 352 off until next week. That way we don't have to
because
come
if
back.
it's a non-germane amendment, you gotta put it into the calendar.
Right.
And if you're gonna modify it, Okay, I'd like to go ahead so we can tackle what we have to tackle here. SB 352, this is a bill relative to substitute teacher criminal history record checks and parental notification of confidential student information release. We also had a non-germane amendment, which was brought forward by Representative Cordelli. Evidently, there was a lot of discussion regarding this during the non-germane hearing on that amendment. And there are some issues that the non-germane amendment proposes to do, which there are quite a lot of questions that are generated as a result of that. I think there's questions enough there where it'd be inappropriate for us to act on that amendment today. And to put off this action on this bill till next Tuesday when we have the other 5 remaining bills. We need to contact both the Department of Education. We need also, Representative Cordelli's interjected here that the amendment that he has needs some revision, needs some changes. That in itself would mean we'd have to get a new amendment made. Any new amendment that comes back that's on that same topic after talking with the clerk does not need a separate hearing. This would be an amendment which is on the same topic that we had heard this morning, and it would be simply brought up in executive session as we do any other amendment. But I don't think we're ready to move forward with that amendment, and we may not have any amendment, but there's some questions that need some resolution before we move forward. So with that, I don't think there's any further action to be taken today. Hope everybody had a good lunch. But we don't need a motion to adjourn. We're out of here. So that's it. So I thank everybody for coming back. That leaves the 6 bills left on the docket of the 13 we had that came in from the Senate. 6 bills left, which we would address next Tuesday. And those bills have to be out of committee by Wednesday of that week. So whatever is brought forward as far as amendments are concerned, the amendments have to be, the way we're going to either act on them or not act on them. So, thank you. I would encourage anybody that has amendments to share those amendments with the total committee prior to waiting till Tuesday. So if you have amendments, we'll try to email everybody so they have copies. If there are non-germane amendments, and there will be a few possibly for next week on I don't know which bills, but there could be. Those we will have, of course, those have to be in the docket by Wednesday, by tomorrow in the calendar, so you will see them. What's easier for you?